Yeah.
Good morning,
Hey,
everyone.
Johnson.
Good morning, Charlie and Mr. Papowski. I think it's okay for me to call Charlie. Charlie, this morning we could hear
Hope
you as
so.
we started, just so you're aware.
Yeah,
But
I
good morning
appreciate it.
to everyone.
Good morning.
Welcome to our forum this morning, where the commission staff would like to have a conversation with interested stakeholders regarding the commission's transportation regulations post Senate Bill 1045. Um,
Mm-hmm.
Today's forum was noticed to begin today, Wednesday, June 22nd at 10 o'clock a.m. in the Commission's hearing room. And if we can proceed at this point to note on the record those persons whom are present and participating, I'll begin with the list of pre-registrants or registrants. Mr. Adam Wells, are you available? Okay, not at this time. What about Mr. Sam Birch? Okay. Mr. John Haruska. Am I pronouncing did I pronounce your name correctly?
Yes, ma'am. It's John Harushka. Yes,
Harushka.
and Sam Birch is also with Way Forward Transportation. He won't be joining us. He had another commitment today. I'll
Okay.
be the representative for Way Forward.
Okay, well, glad to have you here today, this morning, Mr. Haruchka.
Thank you.
Yes, sir. Miss Angelica Mijares. Attorney Jack Pringle.
Good morning, Jocelyn.
Good morning. Good to have you. Mr. David Popowski.
I am here. Unfortunately, I'm going to have to scoot out in a minute
Okay.
because of a deadline.
Okay.
Um, but I'll leave you in the trusted hands of you yourself and my colleagues, Mr. Trini and Mr. Pringle, too.
Well, good to hear your voice this morning. Thank you for participating in the portions that you can.
Okay.
Charlie Terani.
I'm here.
Great. Welcome. And Attorney Nicole Gibbon.
Good morning, Jocelyn. How are
Good
you?
morning. I'm fine. How are you?
Very well, thank you.
Good. Did I omit any? Oh, Mr. McGill is here. Thomas McGill is here from the Office of Regulatory Staff. Glad to have his expertise also in the hearing room. So, everyone, I just wanted to remind for those who are participating in other Class E household good movers or hazardous waste for disposal carriers of the Commission's order, which was issued on June 9th, 2022. Ms. Producer Purpose, would you please display this order that's on the desktop thank you so much. So the commission issued order number 2022-407 on June 9th. And just as a reminder, it was sent to Class E certificate holders by the clerk's office. Basically, in this order, the commission instructed the clerk's office to notify all current Class E certificate holders, that the Class E household goods certificate holders, that those certificate holders' rates, which were on file at the commission on June 9th, would be posted on the commission's website as each carrier's maximum rates. Okay, if it should the Class E certificate holder or should a Class E certificate holder need to amend that tariff, of course they can do so pursuant to the new law. But just wanted to make sure all Class E certificate holders, household good certificate holders, are aware of this commission order. And once again, that's Commission Order 2022-407. Thank you, Producer Purvis. Okay, so if I'm going to ask all the participants if you're okay with us proceeding in this manner. So yesterday we posted commission staff's draft changes, okay, to the regulations. And of course, I know that everyone will provide his or her input this morning regarding those changes. We incorporated, for example, or we deleted references to P, C, and N, also deleted references to public convenience and necessity. You'll see also where there's some sections that have been struck that,
David Papowski.
Mr. Popowski, we can hear you too, okay?
Hey, AJ, listen.
Mr. Popowski,
We're settling up on this
can
whole
somebody,
Atlanta accident
can you mute
case.
him?
Hold on
I
a
just
minute.
want to, no? Okay. All right, great. Someone, Are you a certificate holder, motor carrier? Do you want to participate this morning? You would listen? Okay, all right. I was gonna identify you, but let us know if you have something to say, okay? So, you'll notice where there are some sections that were deleted that were not discussed during our forum last year. For example, there's a section on publication. There's a section on when a hearing will be held. We discussed alternative rates and binding estimates, and I struck that language and did not include the proposed language from our workshop last year. So please bring, of course, I know you will, just so you understand what my thinking was for the additional language that's been struck. I was just, in my mind, this language, these regulations conflict with Senate Bill 1045, okay? All right, so we can proceed. Has everyone had an opportunity to look at the regulations we filed yesterday on DMS? Jack, you?
Yes.
Okay. Nicole?
Yes.
Honestly, I'm looking at them now.
You're looking at it? Okay.
I'll follow along.
All
Well,
right.
Well, obviously that's what I did too, but I'm
Okay.
trying to appear like I'm more prepared than I am.
I know they were out in my mind. I was trying to figure out how we're going to do this now. But what I'll do in Article 1, everyone, I'm just scrolling through that because I'm quite sure no changes were made in Article 1. Okay? And then I'll tell you the page, I think, where the changes. Well, let's see. I said there weren't any.
Go ahead and delete Article 1 while we're at it.
You know, that's a good point, Charlie. I think we should.
I mean,
So-
we don't need to dwell on this, but
Right.
I mean, honestly.
Okay, I made a note about Article 1. That's a good point. Okay.
And if anybody can define what wholesome water means in Article 1, I'd be interested to know the origin and history
Yes.
of that. But
I'm not sure.
Wholesome.
Wholesome water. Yes, I'm not sure about that. I'm making a note, Jack. I'm making a note about wholesome water. Okay. All right. So beginning Article 2. Now, what page is this on? Oh, yeah. Y'all have the what page, Jack? Did you say
11? I think.
11? Okay. So beginning on page 11, everyone. So scrolling down, the definition of terms, section 103-102. As you can see, the references to a PCNN, a certificate of FWA, charter bus certificate, has been deleted. PCNN in the next section, public convenience and necessity.
May I ask a question?
Sure.
Are we now going to have two, a fit, willing, and able certificate and kind of a generic certificate, or is everybody just going to be fit, willing, and able?
Well, the FWA, that's a good point. FWA applies for those operating within a municipality.
I'm just asking what the certificate. I mean, it looked to me when I was looking at the regs, I didn't look at your regs, but I did look at the regs, that a Class E certificate holder will still have to prove that he's fit, willing, and able.
That's right.
So I guess my question is, isn't the so-called certificate in 1095 really a fit, willing, and able certificate? Isn't that what everybody's going to have?
Well, I think so, Charlie, but I thought, okay, let me find the section on FWA in our regs.
Okay.
It's 102. It's on page 12, 103-102, number 2.
And by the way, where's Belton and Frank?
Charlie,
Peg, where are they?
I don't.
Look, listen, it's fair to say, Charlie, that we have, I thought about this morning, the titans of the South Carolina Public Service Commission Transportation Bar participating right now, and no more needs to be said. And I called George Parker to the stand.
Titans. I hear you.
Mhm.
That's an awesome name.
But I think that's where
Okay.
the definition of FWA, that exclusively within the municipality.
Yeah. Okay.
But don't you have to prove FWA for
You-
your certificate?
You do. You do. So I mean, Charlie, since all carriers now have to prove fit, willing, and able, I don't know that they're unless the certificates need to be distinguished. One called a certificate and other a certificate of FWA, because that type certificate, the latter, the carrier can only operate within the limits of the municipality.
Mhm.
But I'm not sure
confused.
that it's.
I was just trying to clear it up
Yeah.
for myself.
I think
We don't
it's
need to
still,
dwell on
I
it.
think it's
Sorry.
still a term of art, and it may still have, and I don't know whether we want to, jump already to this, but I guess that where that comes up again, Jocelyn, is, and it is skipping ahead to 103, 135
Okay.
on page 29, the sale, lease, or transfer of a certificate.
Okay.
Right now, there are provisions for both the sale or a transfer of an FWA, what you just mentioned, as well as a certificate of PCNN. My first thought was, given that the transfer of a certificate, not FWA, but of a standard Class E, was predicated on the idea that you didn't have to make the showing of public convenience and necessity, but you could demonstrate fit, willing, and able in the continuous operation.
Mm-hmm.
I wonder whether that portion still has any relevance now, because if you still have to show fit, willing, and able,
Right.
why are you going to transfer a certificate from one carrier to the other? If you see what I'm saying, I mean, you have to show fit, willing, and able. So would that regulation still be meaningful or useful?
135.
What's that?
135.
135. And there's still something in there that talks about transferring a certificate of FWA that within an exclusive, within a municipality. I've never seen one of those done, but I guess I wonder, to ask the question is this a regulation that still matters now that there is no public convenience and necessity,
Yeah.
and everybody has to show fit, willing, and able?
Right. I'll study it some more, Jack. That's a good point.
I don't even know if we have any Class E FWAs anymore.
Okay, Janice is in the hearing room, everyone. She said she's not aware that any certificate of FWAs even exist anymore.
Oh, and that's a fair point too. Now to ask if what you're, and that's a great point, Janice. If what you're talking about is just looking at, well, you're looking at fit, willing, and able, putting aside that term, but you're not really looking at exactly where anybody operates.
Right.
That's
Right,
why
because you're not looking
there'd
at
be
the
no
public convenience
reason
and
to-
necessity.
Yeah.
Yeah, right.
to want to operate in a town anymore, because you can operate in a state.
And if you did, the advantage is it wouldn't make sense relative to the commission, but presumably if you operated only in a municipality, there's gross receipts and taxation considerations, but that doesn't necessarily have anything to do with the commission at all.
Right. All right, so I'll look at 135 again to see if we need to leave it or.
And Jocelyn, from
Yes,
from the perspective of ORS, I think that we would want some sort of notice mechanism if the certificate were to be transferred, just so that we would know who the original owner is and who the certificate would be transferred to.
Right.
So, in your consideration, if you could look at that as well.
Okay. Yes.
Yeah, that's a good point. Although, you got to make the fit willing. I mean, you got to come to the commission. So I think you'd probably end up knowing, but I don't know. But maybe there'd be instances where there'd be people trying to get around that. But those are good.
They're so easy to get now. Why even transfer?
Yeah, exactly. I mean, what benefit would you get from,
Yeah.
although,
Because what is it, 80, 82, 83, 84, they're of no value
Yeah.
anyway.
yeah. Good points.
Thank you. Thanks, Nicole. I'll keep that in mind too. For yeah. Okay, so we're gonna need to revisit 103, 135, the substance of it, and see what should remain, and what should be deleted. Okay, so we were in 103, 102. We were still in the definitions, everybody.
Let's get out of that.
You want to get okay? Everybody's okay.
No, I'm kidding.
Oh, okay.
We just got you sidetracked already.
Well, yeah, that's okay. So maybe I also need to look at, of course, the certificate of FWA right here. Also, I just overlooked that yesterday. I was really looking for public convenience and necessity and PCNN. All right, and then now ORS and Charlie and Jack, Mr. Popowski, you will notice several of these changes we talked about last year. For example, in which in number 6, remuneration is determined on an hourly basis. I think that's what Class C charter. I think Thomas, you and Nicole probably recommended that change. I think the definition for Class C non-emergency certificate, the new definition, that's an ORS, the stretcher van, ORS. This, we just renumbered the definitions. Driver, that's another change. Number 14 was recommended by ORS last year. And then 22, I think I'm correct that was an ORS change also to non-emergency vehicle. And number 29, wheelchair van patient. Okay, when we added, ORS recommended that we added wheelchair accessible vehicle and to amend the equipped to carry. And so that's the end of the definitions. Okay, all right. So then next in Class A, 103-110, I just deleted, as I told you, that reference to public convenience and necessity. And PCNN at the end of the 103-110, 103-111, same thing. 103-112, 103-114, PCNN or FWA. 115, 130. The reference to certificate of PCNN, certificate of FWA, and charter bus certificate, because I think they're under the new statute, they're just called certificate. The certificate is just called a certificate. Right. Yes, deleted this publication of notice of filing only because I think the bill, the new legislation addresses how publication of the applications and a hearing are to take place. Okay, now we get into the good stuff. So we know we need to delete PCNN, which we have, and then the reference here. I think I deleted that yesterday, but then we get into the criteria for fit, and so as you know, we talked a couple of weeks ago about the substance of the Commission's transportation applications. In certain forms, there was an exhibit, or is an exhibit, called Exhibit Fit, Willing, and Able. We had a discussion about the safety certification and all that other. I noticed.
Raise subsection A, Jocelyn.
Yeah, go ahead, Charlie.
The safety certification, we were talking about that.
Yes.
And paragraph A reads, the applicant must demonstrate, or the commission determines that the applicant's safety rating is satisfactory. This can be obtained from US DOT and South Carolina Department. of public safety records. And I think we were discussing the fact that 99.9% of our applications have applicants that are exempt from safety ratings.
Yes.
And this reg doesn't even talk about an exemption.
Right. And
I wonder if that needs to be revised.
right. I think yes. Charlie, I spoke to a lieutenant yesterday at State Transport Police trying to determine what that agency does, who they govern as it relates to safety ratings.
Yeah.
And Lieutenant Norton told me that their agency, if the carrier transports 16 or more, he said 16, the driver plus 16, no, 15, the driver plus 15, then State Transport Police can, and that they do at times issue safety ratings for household good movers. But until we change this regulation, Charlie,
Mhm.
let me go to something else I want to show you.
Okay.
The application form to see to get thoughts about using this language perhaps on the safety rating. I'm sorry. It's currently called, this form is currently called Exhibit on Fit, Willing, and Able.
Right.
So does applicant have a safety rating from US DOT if applicable?
Mm-hmm.
Until we can figure out exactly the type of language or what needs to remain in the regulation. Maybe everything, maybe the language as it relates to the safety rating in the fit part of the regulation needs to be deleted. I'm just not sure at this point. Or does it need to remain, and then for the purpose of our applications, we include language like that, if applicable.
Okay. My suggestion would be to delete the first sentence.
Okay, going back to the fit. All right.
Yeah.
Jack, you were going to say something?
Although, I think I would agree with that, although it certainly could also say, and this is for another time, but the applicant must demonstrate that it's safety posture. Or, I mean, you remove the term rating, and then you could say this could be shown by USDOT safety ratings, and then continue with the additional. But but the key is to take rating out of there, because given that, I mean, it could be helpful and it could be used to demonstrate this, but it's not going to be. The commission's not going to determine that the safety rating is satisfactory. So, but I think that language could probably be revised to reflect the way, as Charlie points out, it's in practice, it's been forever. No, we don't have it, but yes, we understand the regulations that apply to us, and we agree to follow them.
Okay. Jack, what if we talk about leaving the last sentence, the applicant, instead of further, the applicant should certify they're familiar with all statutes and regulations, including safety operations in South Carolina. Would that be probably sufficient?
I think so.
That's what everybody does.
Okay.
Yeah. And you could leave in there that part about the outstanding judgments too, I guess, if you wanted to. Yeah.
Okay. Now let me ask you, Charlie, Ms. Rapowski, Nicole, I don't want to leave him out, Mr. Haruka. Look at this for passengers. And then I'll scroll back to this one. Okay, passengers is here, number 4.
Mm-hmm.
And under fit, you notice where it indicates no outstanding judgments and that the applicant is fit to do business as a certified carrier. Mm-hmm. But I don't know why the part about the applicant being financially fit is not in the regulation that governs household goods and hazardous waste.
Yeah, I don't know.
And just want your thoughts about making those consistent, unless you all have some idea.
See, having you point that out for the first time, I'm now going to go back and ask a discussion with a particular commissioner about financial balance sheets be struck from roughly 35 transportation hearings that took place. I'm sorry, I digress. But I'm not sure exactly how that fits in. What does it mean? What does it mean in the passenger context? Any different, or does it?
We don't. It doesn't look. We don't look at that any different.
Mm-hmm.
Sorry, I'm
That's okay.
No.
So we nobody knows right now. Do you have a problem with the two being consistent though? Like, no outstanding judgments, and the carrier states that it is financially fit to do business.
But if we're going to leave the balance sheet in, I
Well,
think
that's Is the balance sheet is still in the application for the for?
Well, let's
Class
say
E?
it's not.
Oh, it's,
Let's say that it's not. Let's say
Right.
for some reason that it's not in there.
I mean, if it's not going to remain in there, then I think for consistency throughout the regulations, then it should be struck.
That's
but
a
if it's
hypo. That's a hypothetical.
right,
Yeah.
hypothetically,
Okay.
Yeah.
All right.
I'd vote for deleting that balance sheet.
Yeah.
I don't understand the purpose of it. I mean,
Yes.
I've never seen anybody turned down because of an inadequate balance sheet.
Okay.
Agreed.
Yes. Okay. Awesome. All right. So, I think what we're saying at this point is the last sentence under fit would cover the safety operation, certifying that they're
Yeah.
okay. Great. All right. Then the next one, Nicole. I think this was a recommendation from ORS under ABLE, or at a minimum provide documentation of a quote for a purchase. Does that sound like, or lease on a long-term basis?
I think so. And I think it just recognizes that there are certain carriers that when they apply for authority, they don't have their own equipment, but are going
Yes.
to lease through enterprise. And I think it makes sense for them to document that they at least have a quote or some sort of documentation reflecting that they intend to on the equipment.
Okay, great. So that will remain, and then I don't recall. I know staff is of the position that the last statement should be deleted under ABLE. I don't recall, really, Nicole, if that was an ORS recommendation or not.
Yeah, I
Oh,
think.
look, no.
Yeah, I think that was an ORS recommendation.
Awesome.
It should go.
Okay, all right. And then the next, we're now under contract carrier authority, PCNN struck, once again, under B, PCNN, and then the language referring to how public convenience and necessity is proven, that's been struck. Now we move to passengers.
Mm-hmm.
Same type language has been struck. And then under fit, we will strike the safety rating and leave the last sentence. Non-emergency vehicles. Nicole, I'm quite sure these were ORS's suggestions to update our regulations with the federal law. Okay,
Yes.
great. So I think everyone has seen this suggested language, suggested strike throughs, deleted language. These were all in Office of Regulatory Staff's proposals from last year.
There are a lot of gendered pronouns in here.
Are there? Okay,
I mean,
we'll
it's
look for
problematic.
those. Thank you. That's important, Charlie.
Well, no, really, there is a lot of he,
Okay,
and there are a lot of he's.
thank you. All right, moving on down. Okay, if I'm moving too fast, everyone just say Jocelyn, stop there. But I'm
Just tell
scrolling.
us what page you're on, though.
All right, I sure will. My PD, I'm going back to my paper copy, Charlie. Hold on one second. So
Okay.
we're under 6.
Okay.
So look on page 21 on over to 22.
Mm-hmm.
Okay.
So we're still on the criminal background check?
No, Charlie. Okay. Now that you're talking about the application, I heard you loud and clear on the application. Okay. And those are up. Those are before the commissioners tomorrow. So everybody just tune in. Tomorrow,
okay.
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 For the application.
So these are the
But no-
driver
Right.
qualifications for passenger vehicles.
That's correct.
Gotcha.
Okay.
Sorry.
No problem. So this is the end of page 22. 23, and these should look familiar. These are Office of Regulatory Staff proposed changes, and staff agrees, and so we included them. I think part of it here, Nicole, too, was to strike language to specific federal statutes because the sections could either have changed or could change, and so that was some of the reason for, you'll see just state and federal requirements instead of specific federal legislation.
Thank you.
Okay, then we have PCNN, of course. This has been struck on page 24. I'm at the bottom of page 24. The definition for engaging in business has been struck. 25, you'll see at the bottom where PCNN has been struck. We're now on 26. Stretcher vans. PCNN, public convenience and necessity. And we changed the definition at the beginning in 103, 102 from wheelchair van to wheelchair accessible vehicle. That's an Office of Regulatory Staff change. Page 27, no changes. Page 28. So this is new. I struck this language yesterday at the bottom, when hearing may be held, because I think it's governed by the legislation.
So your idea, Jocelyn, is you just don't need the legislation tells us when there needs to be a hearing. So
Yes.
we really just don't need a reg.
Yes, sir. And I've appeared before a committee at the General Assembly before where that was not looked favorably upon, that we basically taken language from the statute and included in the regulation. So
I see. Okay, I've got no problem with it. I'm just,
yes.
that's not what we've done in the past. That's all I'm saying.
Yeah, and the only thing and don't disagree with that at all, unless, and I have to admit, not having looked at it closely, about whether there's anything in the statute that you would, not that you would deviate from, but that would just be clarified for procedural purposes when you, within the reg, and would, make it smoother and more straightforward. I'll certainly look at it when I get a chance to see whether, it would make sense to just, again, just explain it in the same way that the current reg is done.
So the legislature's told you they don't like you mirroring the statutory language of the reg?
Well, I had a situation where we did, Charlie, basically, I don't think the regulation was before that committee for that particular, I think we were amending it. I've had that happen within the last 10 years, where we basically,
I'm raising it is that, what we become accustomed to is you can kind of pull up the commission's regulation and it takes you from soup to nuts in an application.
Mm-hmm.
And if now you're kind of bobbing and weaving between the regs and the statute, seems like it's going to be confusing.
Well, I don't have a problem. For example, something Jack mentioned, if there's something that's more detailed perhaps in our current practice than the legislation provides, if we want to say the commission's, the maximum rates, I think it mentions our website. And if we want to talk with more detail about like our procedures, yes, ma'am.
Sorry, were you just going to say that the legislation as ratified mentions your website? It does. What I was going to say with regard to this regulation concerning when the hearing can be held, if the intent of the regulation is to provide instructions to potential applicants, is there a way to perhaps split the baby and craft a regulation that would essentially provide that instruction to applicants without directly copying the statutory language that we all could take a look at?
Right. So
That's
let me
what
see.
I was saying, really.
Okay, so if we can look at the one for the hearing, which I think is under 210, 5823 210. Yes.
Yes.
Okay. See, Nicole, I'm trying to find out what else I'm trying to find out what else we can say that the legislation doesn't say.
Yeah, and I'm not looking at right now, and we'll certainly do that, but just even if it just, well, then maybe the rules of practice and procedure already talk about this, about the specifics of applications, but if there's,
Well,
not,
I'll tell you what. Here, we got all this new technology here.
yeah,
Hold on a second. Let me show you something.
okay.
Producer Purpose, would you show the document camera? You can't.
Yeah, okay.
she nodded her head.
Written application, commission's form,
Uh-huh.
post information for 15 days.
I'd have to think long and hard, like what's here, in our current practice that's not in the statute.
Josh, and for
How
the
to file an objection.
How to file an objection? Okay.
Well, in other words,
That's a good
the
point.
statute just presumes that somebody might object, right?
Yes.
So what's lacking that could be put in the regulations is if someone objects to an application, they shall file an objection within X days, and the commission will hear that objection. And I don't know if the statute says how long the commission has to hear the objection.
It said, yeah, Charlie. Well, that's under 2, right? B2. If an objection is filed, the commission must hold a hearing to determine FWA. The commission must publish a notice of the hearing for an application on the commission's website for not less than 30 days before the date of the hearing.
Well, and I don't want to make it too complicated, but at the very least, it could potentially, if there were a reg on this, to say is that an objection, it could reference those timeframes, but say, consistent with 5823-210, an objection will raise those points in the fit, willing, and able that somebody objects to, that describes describes the objection.
Okay.
And then also, if you're going to have a hearing on it, there probably needs to be a reference to whether or not, and again, this may get beyond, as to whether or not you'd say an objection shall comply with, and then talk about the rules of practice and procedure, whether it's a petition to intervene or a protest.
Yeah.
Because if you have a hearing and that's not clear, then you've got the question about whether or not the objector can cross-examine the applicant and such. So I think it probably makes sense to at least describe, so that, because without that, if you just, not that it wouldn't necessarily, but if you kept it that way, somebody files an objection and says, I object. You go to a hearing and you have, and especially if somebody's not represented by counsel or you could have a situation where there'd be some real confusion about exactly what does everybody get to do.
Right.
And I don't know that this anticipates that there would actually be testimony, but holding a hearing to determine if fit, willing, and able, it may very well be that if this ever happens, and nobody will ever oppose anybody I represent because, you know, again, my clients have never been wrong about
Yes, of
anything.
course.
But would there be a procedure that packages that information before and I don't know whether it be testimony, because testimony hasn't typically been used in transportation hearings, but at least to sort of frame the way the dispute is, or the way the disputed hearing is going to be conducted,
Yeah.
might make
I
some
think
sense.
Jack makes a good point.
Right.
I just experienced with one of my clients, you know, somebody objecting really just to throw sand in the gears of the application. And so some procedure for the objection. The other suggestion I might have, Jocelyn,
Okay.
is it might not be, you know, maybe you could consult with PERC and see with PERC staff and see how they feel about this issue of, you know, not putting something in the statute in the regs, because I think Nicole makes a very good point. A lot of these folks are going to be lay people reading this thing, and the idea that, you know, they should know that there's a statute out there that provides for some procedure, and they should kind of go back and forth between the code and the regs, I think is really kind of confusing, and I'm not sure the PERC would object
Okay.
Yeah.
Okay.
to fleshing this out.
Okay.
And Jocelyn, just so that
Yes.
the record's clear, you know, ORS did not have an objection to striking 134, but I think we would be willing to review anything that outlines either the process for the objection, or if you were to go to the PERC and say, you know, here's what we're putting forward, and they were to, you know,
Say that
essentially
again.
bless it,
Right.
we'd be willing to review it.
Okay. I'll do that. And I think you all are probably, I'm going to skip to the publication. I'll come back to this because I think
Okay.
you're probably going to tell me the same thing on
Yeah.
the one for when publication is required. Well, I don't know if you'll say the same for that one. That would be number, let me find the number. There's another regulation. Hmm?
193.
193. Thank you, Thomas. And that's on page,
45.
thank you. Hearing and publication on new rate schedule.
Right. We don't need that, do we?
Yeah, this looks to be like on a tariff. Yeah, Charlie, I think you're right. Yeah. Because the objections are for new application or an amended application, not to rates. So, okay, so we're okay on 193.
Yes.
Okay, all right, makes sense. Thank you all.
But sticking with 50, I'm sorry to go back
No,
to,
no.
to 210.
Was that-
Again,
Oh.
the statute.
Okay,
It's there is, and you don't need to put it back up there again, but there is, the commission will notice, there'll be some particular notice of the application that goes out in what?
oh,
Just,
so it's on, you mean when there's an objection or just when an application is filed?
when an application is filed.
Okay, so that's, I'll show you that, Jack. Okay, so that's on our homepage.
Yeah,
And
okay.
then it's right here, pending transportation info.
Yeah,
This is where we notice pending applications.
okay, and that will be the notice that a potential objector
Yes.
can go and see, and okay, and that, all right.
And that's for 15 days following receipt, I believe.
Yes.
Mm-hmm.
Yeah.
And then what's the timeline for a hearing
30 days.
from?
For the 30 days is, well, there really isn't one. It just says that the commission has to provide the public at least 30 days notice
If
Okay,
there's
so
an
that's-
objection.
if there's an objection.
So that's to make sure it's clear with the Administrative Procedures Act.
That's correct.
Okay, that's what I was just, I mean, and I know you already did this. My apologies for,
No problem.
I'm just thinking through, just making sure, and I completely agree with Charlie, is that I do think, almost at the very least, even if there was a reference in a reg to, per statute,
Okay.
that sets up this process. But then I think it'll make it easier for the commission staff and everyone else if everybody knows who they are and what they're doing and what they, what's going to take place. I mean,
Right.
is it going to be objections that are filed and then you just go straight to hearing, or then you have the opportunity to, but I've already said this. Sorry, keep going.
Yes, I think we focused initially on, okay, if you object, well, what must be included in the objection?
Yeah.
Just like you have I think that's a great point that's been made. Just like for a petition to intervene, this is what must be included.
Mhm.
Or should, yeah. And there should be criteria for what should be included with specificity in the objection under 5823-210.
Right. And
Makes sense.
It may even, and this may be more than you want there, but it might have some of that same language that you'd see in some of the notices of public hearing in other instances. Like, if you want to object, do this. If you want to file a petition to intervene, you got to do it according to this reg.
Oh, okay. So look at our new notices. That
Yeah.
language from the new notice.
Just so that, so that, again, it's framed, and I really am not trying to make it sound, more complicated. And maybe it wouldn't be. Yeah.
When Charlie started talking, I just envisioned everybody coming in here for a hearing and looking at each other like, okay, why are we here?
Yeah.
If the person who is objecting does not state with specificity why the fit, willing, and able standard hasn't been met in the application.
Yeah.
And everybody would be in the hearing room at the appointed time, just staring at each other like,
Yeah.
the objection didn't say anything. Why are we here?
There need to be some requirements for the objection. I'm
Yes.
not sure you need a prevention procedure. I don't know. Let's think about that. Because, I mean, Jack, you've only got so much time to do this. I think
Right.
the statute contemplates that if there's an objection, there's an objection. The commission's going to hear it and get it
Yeah.
over with and not drag it out. So intervention just adds another step. I mean, if somebody objects, the rag probably should say you gotta explain why you're objecting.
Yeah.
And if you don't sufficiently state your objection, it's subject to dismissal.
Yeah, and maybe the concern about, and I'm just overthinking it in terms of objections and somebody thinking they can come in and cross-examine a witness of an applicant. I mean, that's on whoever, you could become a party of record if you wanted to, and maybe that wouldn't be, it wouldn't be an issue. And maybe it is, you object, you make your objection and move on.
Yeah.
Well, Jack, what if ORS objects? Well, I guess ORS, how does this work? Does ORS just refuse to grant the certificate and then it's on the carrier to appeal?
Well, no, you know what I think, Charlie? Because they're automatically a party of record, right? So I'm thinking they could still file their objection with specificity. I do think what you said, Jack, needs to happen with everybody else. I think that they need to file the objection with specificity and also include some of the elements from the petition to intervene. What's currently those that are the standard that's currently in the petition to intervene regulation. Am I making sense? Because other than that, anybody, I mean, you could not even conduct business here, live here, and be in another state, and maybe you have a personal vendetta. Does that make sense? I mean, where's your standing?
It does make sense, although I think and that's where you run into what the statute makes it clear is that there's not to be a procedure where there's a petition to intervene, there's a response in opposition to a petition to intervene,
Okay.
or presumably not. But that, I am interested, like Charlie said, is if the ORS evaluates the application, and let's say, for example, you have, somebody who's been out of service a number of different times, has all these violations. Let's just say, for example, that there are allegations that a a passenger carrier has been taking people to and from a certain establishment in Greenville. I'm sorry, I digress. And they want to present that. What do they file their own objection, and how would they present it at the commission? Would they, I mean, they put it in writing as to say, presumably our investigation was done and we found X, Y, and Z, therefore we have to, would there be there wouldn't be a denial, would there? Or would there? There'd be an objection in the same way that a party from the public would object?
Right, like normally, typically, when if a proceeding is normally we receive the pleading and then we issue a notice of filing. If there's no objection, typically staff will ask the commission to consider it,
Yeah.
unless ORS says they have a problem.
Yeah.
Other than that, we put it on the agenda. But when a petition to intervene is filed, we kind of slow down our procedures in the
Right.
clerk's office and we anticipate a hearing.
Okay.
I think if ORS, from that page I showed you earlier, the
Yeah.
pending, once they see the deadline to protest, I think ORS can protest. And when they do, then we would then schedule the case for hearing.
Okay. And
That's how that would occur.
And just thinking ahead to that, putting aside what the statute or the reg says, my sense is that there would be an expectation that we want to hear from Mr. McGill
Right.
or Miss Rowell or whoever it is on
Right.
this, and essentially put somebody on the stand.
Yes.
And that's fine if we keep doing it the way that we've done it without it being pre-filed necessarily, but as long as everybody has an idea of how that's going to work.
See, Jack, I think we issue pre-file letters even in transportation cases now, don't we, Janice?
No.
Well, you know what, Charlie? The application is
before. You
considered,
used to.
the
Yeah.
application is considered the applicant's testimony.
Yeah.
That's why for that. But don't you issue one for the rules? Rule to show cause.
No.
But how much time do you have to do this under this statute? That's what I'm trying
To do what, Charlie?
15
to
days.
hear an objection.
Oh, the commission then, once the objection is filed, we just have to provide 30 days notice of hearing. Yeah, in my reading of B2, the commission doesn't have a deadline. It just needs to provide 30 days notice of the hearing.
So there's some suggestion that it looks like it's supposed to bypass any standing issues or questions between the parties and you'd go to hearing. But the other side of that is that if the commission wanted to, it could just follow its normal rules of practice and procedure.
Well,
This is where I'm concerned, and this is where regulations I think would be helpful.
Okay.
What's to stop, let's say Allied Van Lines or somebody from just coming in, no aspersions on it, let's call it Acme Van Lines, from coming in and just objecting to every application and throwing the application on a 6-month or even worse delay, because then the commission is going to publish notice of hearing and we're going to have pre-filed testimony and we're going to hear petitions to intervene. I mean, I'm thinking of my recent guy and my recent applicant who had just that happen to him, and he's sitting there because of a quirk, but he had to reapply for a certificate. He's got payroll of $15,000 a month, and he's hung up on the docket waiting for a certificate just because people or competitors are filing objections. I really think the commission needs an expedited process for this. I would much rather not have to fool with a petition to intervene if I'm representing an applicant and just get to the substance of things in 30 days than have a petition to intervene, argue it in front of the hearing officer, have the hearing officer's decision appealed to the commission. And meanwhile, my clients, I've got $4,000 or $5,000 worth of fees just before I get to the hearing.
Now, Charlie, let me for you and Jack, let me clarify what I was talking about when I mentioned the PTI. Okay, What I was talking about was the language, similar language that is similar to what you find in 103 8253. Okay, so the facts of the petitioner's alleged right or interest, the proposed grounds, it says for the intervention, but this would be for the objection, and then their position. That's what I'm talking about. If we are trying to create a standard so that to minimize frivolous objections from being filed, that's why I mentioned the petition to. That is what I'm referring to. Something language that's similar to that. So I mentioned the standing issue. Where your right, you must allege. What's your right or interest? Okay. Why are you objecting? What are your grounds with specificity for objecting? Okay, that's what I'm talking about. And then what is your position? So I don't want somebody.
Okay.
Yeah.
No. And I get
now
that.
Let's assume they clear that bar.
Okay.
Prima facie.
Okay.
I'm not sure what standing is, but I imagine a member of the public could have standing to object, saying, the driver's a drug addict or something like that. Let's just assume they clear that bar.
Okay.
Of standing, of a prima facie allegation. How quickly, and I think there's clearly a public interest in it, and I think the legislature is sort of indicating by passing this bill that they're interested in expediting this process.
Okay.
How quickly can we get rid of this?
Okay, so then I think then, Charlie, then that type language for the time frame, I don't think we'd be stepping on the toes of the legislation. I think that time frame to dispose of that case could be addressed in our regulation.
Yeah, and I'm suggesting we do it. I remember when we were at the commission back in the day, Jocelyn, when customer complaints used to get dragged out, and somebody filed a complaint saying AT&T dug up my pansies.
Right.
It would take a year and a half.
Right. That's right.
And I remember a certain state senator calling us up and saying, "Why did it take you a year and a half to decide whether AT&T should have dug up this person's pansies?" And we didn't really have a good answer for it.
Right.
So that's why we came up with that expedited process. And I think we need something like that here.
Okay, well, Charlie, let me ask you this, because I think we fare off better at this point, because the hearing examiner, remember the hearing examiner statute, that special agent statute, I don't think is in the chapter 23. And so if the time frame will be, let's say we have 30 days, but then we have to dispose of it within 45.
I think it's great.
Because that's 30 days for notice under the APA, and then 15 days to, the commissioners to make a decision. So, and then for staff to issue the notice, all of that would be done within 45 days. And I think that was the intent of when we changed, as you mentioned, after the issue with the individual customer complaints. The reason for expediting, I think the time frame was 45 days that we came up with.
Yeah.
Yeah. Okay. Thank y'all for providing those suggestions. I think they're great. All right. So now we're going to return to the regulations. Nope, that's not it. There we are. Forgot where I put my stuff. Okay, we're going to return to, I think, page 28. There we are. And we were down here when the hearing may be held, so I'll be reviewing that and providing some proposed language. And then we're now on page 29, deleting reference to, and then also I'm supposed to be looking at 135 too, to determine what part of 135 is needed for sale transfer, Jack. Remember we talked about that?
That's correct. And I mean, my view is that the whole thing goes, subject to whether or not there's continues to be any significance of having a certificate of FWA, which is specifically, limited to operating within a particular municipality. But not sure that that continues to have any relevance at all either.
Okay.
Why would it? I guess I'm confused.
Okay, what are you confused about?
Why wouldn't the items in B be relevant?
103.135B, Charlie?
103, 103, 135, 3B.
Okay.
Meaning, would there perhaps be instances where a certificate would be transferred?
Yeah.
Well, I
They
think
want
that
the name, they're selling the business, they're selling the certificate with it.
it might be, although the idea is that, maybe they do, maybe you'd be selling all of your operations and that, but at the same time, the thought was that always that the value was, getting those operating rights and the certificate, which, was the real value in including it. And
Yeah,
what,
I think it's gonna be rare, but let's say 3 men in a truck of Charleston, besides, the current owner of 3 men in a truck of Charleston says, I'm gonna move to Tennessee and I'm selling my 3 men in a truck of Charleston franchise. Wouldn't he wanna just sell the certificate too?
he might, and especially because if the name stays the same, it's not clear that
Yeah,
that it would really be viewed as a different fit, willing, and able. So,
well, yeah, because otherwise they'd have to surrender the certificate and reapply, which might be faster.
mhm.
I don't know. I'm just,
Well, and then you
I'm
got
not sure I see the harm in it, is my point.
maybe, I think you'd with that in mind, I think you'd still be looking, or you might consider if it stays that you would also take out but you would take out 103, 135, 4.3 about the continuously offered and reasonably provided for 12 months.
Fair.
Or you'd consider it.
Yeah, the proof might be different, yeah.
Yeah. I mean, you'd still want to show the first two provisions, presumably, or not adversely affect service to the public under said certificate. I don't know what that means, but
I mean, the proof really might be just the same that's required of a new applicant, plus the factors in 3B.
mm-hmm. Those are good points, and query. I can't believe I just said that. Whether or not would a transfer, an application to transfer certificate be subject to the same timeframes as that are set out in the statute? I mean, it wouldn't. I think they should be for sure. I mean, there's no reason they should be any
For
different.
transfer?
Same
Yeah.
procedure,
Yeah.
Okay.
objection.
Okay.
Yeah.
Okay. Okay. All right.
All you would do is just keep subsection B.
Mhm.
So in addition, you would do these.
And when you say subsection B, Charlie, you're talking about 3B.
3B. Yeah.
Yes,
Okay.
ma'am.
Okay.
While we're talking about it, has anybody seen an application to lease a certificate
No.
ever?
I have not.
Hypothecate? Anybody know what hypothecate means? No, I don't. It's not in
It's
this.
hypothecate.
But I guess it could still be, that. I suppose that could still be in 103, 135 too, but it does mention sale, lease, or transfer.
Lease certificate.
I guess, for some period of time, you'd say during the the busy season or the not busy season, we'd let somebody, I just, I don't understand that. That sounds to me like it's something that applied in another time's forgotten
yeah, probably
space.
so.
Yeah.
If they wanted this, back in the day,
Hmm.
if a carrier wanted to,
Talk about another time. You want to read the back of our bill of lading?
Yeah. Have to call the
Charlie
Shire
said
Reeve,
it. Talk about another time. Have you read
Contact
the
the
back
Shire-
of the bill of lading?
contact the
That's
Shire Reeve.
charges.
but they would, like a carrier wanted, this one particular person would want this carrier to move them, but they didn't have the authority to do it. So they would lease on another company's authority. They would lease it in order to move that particular customer.
Huh.
Oh.
Well,
Wow.
But that was probably in the 70s, 80s.
mm-hmm. Okay.
Okay. All right. Thank you for your thoughts on that. We'll get some language together for 103.135. And then protest.
Jocelyn, do we still need 103.136?
That's a good point. I just saw
I don't
that,
think
Nicole.
so.
I don't think we do. Yes.
I mean,
ma'am.
unless a protest is meant to be separate and apart from an objection, I don't know why it would remain.
No, I think 103.136 should be deleted.
Yeah, as long as that provisions of 5823 210 apply to all of the, application, transfer,
Yes.
etc.
Does 137?
Is 137 needed? Let's see, that's amendments. Okay, Charlie, what if the case goes to hearing after an objection's been filed?
Oh yeah, that needs to come out.
I mean, I just don't amend the authority or relieve. I guess I'd delete at least authority.
Okay. Because, Jack, what I was saying is if the case does go to hearing due to an objection.
Yeah, but amending this, if you're just talking about fit, willing, and able, or the public interest of a transfer, it's binary. It's an up or down.
Mm-hmm.
How would you amend your application?
This is amend the authority.
Or relief, authority or relief.
Okay.
Because
Really
you say,
asking. I mean, maybe you got it wrong. You meant to apply for Class E and you applied for Class C.
Could it possibly be a carrier that wants to amend? I mean, I'm not saying that this would ever happen, but could it be a carrier that wanted to amend from statewide to just certain counties?
yeah, see, I don't think that goes back to
Not
what you all
doing-
talk about in the application. I'm not so sure why people are mentioning counties as opposed to statewide without a public convenience and necessity. I don't
Right.
see how those things.
Well, see, and Charlie and I talked about that too, but I because I don't own a transportation company, but I first asked, I think it was Alex. I said, well, do you all like to know where they're operating, where carriers are operating at the last one? No, that was for the application. Okay.
Yeah.
So I asked him that so that their enforcement officers know who's supposed to be operating where. And I don't know, strategically, they might have, their way of conducting enforcement or carrying out their enforcement duties. But then the other part that you asked about, Jack.
It's authority or relief. So, I mean, the authority or relief, I mean, my reading of this historically would have been that that's talking about where you want to move. And, there was a time when that's what you would do during the hearing with the aforementioned Acme moving and as that you would agree to pare back your authority and not have statewide.
True.
But that
I would suggest just striking the authority or relief sought. An applicant may amend his application at any time prior to the end of the hearing held in connection with such application. And
Period.
then I would strike provided no amendments will be accepted that tend to enlarge the scope of just strike, end it there.
Yeah.
You can amend your application prior to the hearing, basically.
And that's just consistent with, oh yeah, we've
Yeah.
got some more information. You know, we've got some more
Yeah.
trucks. We've got some more insurance information. You know, that sort of.
But I have no idea why anyone would apply for less than statewide authority.
And I don't know what the commission would do with it. I mean, the commission,
What's the point?
yeah.
Well, see, Charlotte, we did talk a little bit deeper about the expenses relating, and I don't know what they are. I was just talking. If it's more expensive, I don't know. Insurance wise, I don't know.
It's not. I
It's not, Charlie?
Whenever I've had, the only 3 county applicants I've had are people that already had published their notice and then hired me and said, no, I want to go ahead and get my certificate. I don't want the delay of republishing.
Okay.
Because otherwise, everybody else has gotten statewide authority because they've been told, all we need to do is get a shipper witness. Well, you don't even need to do that anymore.
Right.
So there's no reason
There's no reason. Okay.
to limit your authority. And 90% of people out there with statewide authority. So ORS must be figuring out where they're doing business just by looking at their home office.
Oh, is that what's going on, Thomas?
Yeah.
Oh, okay. Thomas just agreed with everything you just said, Charlie. He said they look at their home office.
Yeah.
Yeah,
And-
okay.
And ultimately, nothing's gonna, what is it Yogi Berra said? Nobody's gonna stop people if they don't want to come out to the ballpark. I mean, nothing's gonna stop a carrier from not operating in certain counties, but they don't need the commission to save them from, the commission doesn't
Yeah.
get involved in that decision.
Right.
Yeah.
Okay.
Jocelyn,
So
I'm
yeah.
sorry. May I raise a point?
Yes.
I don't know that this necessarily conflicts, but if you look at 103, 137, and if we're striking the authority or relief at any time prior to the end of a hearing, 103-133 says that applications can't be amended within 48 hours. So they can't amend within 48 hours, but after the hearing starts, they can amend anytime prior to the end of the hearing.
If we have that other one, why do we even need this?
That is in there. I saw it yesterday.
I would recommend taking that out because that's been practicing at the commission for 26 and a half years, and that's the first time I've ever seen that. And I've routinely amended the application
Within 48
the
hours.
day of the
Oh my God,
hearing.
Yeah, at the hearing.
At the hearing.
Well, and it does, and it says unless leave to amend is granted by the commission. So
Yeah.
you weren't in violation of the reg.
I'm not. Again, I got an ongoing
Well, and
waiver, but
I'm just saying, I don't think
Yeah.
you need both of them. Either 137
Or
goes
one-
or
yeah.
133 goes. And it seems
I mean,
like
if the
137
commission's
probably-
practice is to typically allow amendment, or it has been to allow amendment
Mhm.
without giving leave to it, then I think we would be, I'd have to check internally, but I don't know that we would necessarily have a problem striking that sentence under 103, 133.
130. I think 137 definitely is allows more time to amend. So
Yeah.
we'll delete the first one in 133.
good catch on that.
Can you say that louder, Jack, just in case they're
Uh,
watching?
That's a good catch. That was a good catch, Nicole.
Jocelyn, you realize.
Thank you,
this-
Jack.
This workshop makes the one you held last week look.
Oh, it's awesome.
Yeah.
Y'all are funny. I like it. Okay. So we discussed 133. Thank you, Nicole. 137. Charlie provided us with some new. Well, we're gonna the sentence under 137 will read: an applicant may amend its application anytime prior to the end of any hearing held in connection with such application. Period.
Yeah.
Okay. And then 138. Public convenience and necessity. 139 deletes PCNN, FWA, charter bus. Now, this is new. I don't think you all have seen this before. 140 relates to requests for an extension to comply with the commission order. So I'll read it if, yes.
There's a lag time between,
Yes, in the live stream.
so when you're calling out page numbers, you're usually 1 or 2 pages behind when the people watching come out.
I like it.
It's okay. Thank you, though. Okay, so we're on page 31. Thank you, Charlie. Applications for extensions shall include the current deadline, requested deadline, and reason for extension. And then number 2, the commissioner's understanding of the need for extensions in order to procure necessary elements for certificates. Extensions of up to 1 year will be considered due to cause. Extensions beyond 1 year shall be required to reapply to ensure completeness and up-to-date accuracy of the application.
We had no issue with it, Jocelyn.
All right.
That's sounds good to me. I mean, those are by and large. Now, I mean, it would be for Form E and Form H. I mean, what other things?
No, someone might need.
Would inspect safety? I mean, but there aren't necessarily, you know.
Sometimes, well, insurance is one, but
I'm told by my esteemed colleague that it would be primarily Class C.
Okay. Oh, Class C. So never mind. I mean, I'm not disparaging Class C. I'm just not sure exactly. But I mean, that sounds like a year. I mean, seems a reasonable extension to me.
Okay. All right. And then beginning operations under a certificate, you recognize the stricken language. I'm now on page 33. These are Office of Regulatory Staff changes. Those can be found in their filing from last year. I'm on page 34. 103.1513 ORS recommends that we strike the language in the middle of number 3, provided, however, a tractor permit card may not be transferred to a truck. I don't even think that's applicable anymore. Okay. All right. Page 35. This is also an Office of Regulatory.
Vehicle regs be applicable to movers?
What type, Charlie?
The ORS changes in 10350 number 4.
Oh, motor vehicles to be re-registered?
All these things now are going to be applicable to movers. Because honestly, I mean,
Charlie, I'm told no.
okay.
Yeah, household good movers are assessed.
No,
I guess the
I'm talking
question
about
is whether
vehicle
they
appearance, serviceability and operation. The way is by deleting taxi cab and limousine and putting motor vehicle, it seems like it's applying to any certificated carrier.
All right, so let me back up then. You're on page 33. Okay.
Yeah, and I don't really know why we care if a mover's headliner is torn.
Yeah, under the definitions, back in 103.102, 18, it does define motor carrier means both a common carrier, motor vehicle means any vehicle, machine, tractor, semi-trailer, or any combination thereof which is propelled or drawn by mechanical power and used on the highways of this state.
I mean, I don't know that it's a big deal. I mean, really. I trust Thomas not to ding somebody, a mover, for having a torn headline.
Well, and what's interesting, as you read, Charlie, in some of those definitions, they clearly anticipate that it's passenger vehicles, windows for the passenger
I'm
to
not worried
raise.
about it.
Okay,
Just leave it.
leave it. Okay. Yeah. Agreed.
Okay.
All right.
Moving on. I think we were.
Are autonomous cabs included in this? Have we addressed? Never mind. Keep moving.
103153.
Commission should regulate drones.
I can't wait for that. Passenger drones. Cargo drones.
Cargo drones.
2 men in a drone.
Okay, these are, well, the marking of vehicles under 1531, that was an ORS suggestion. And now, this is placarding, so I'd love to hear everyone's thoughts on this. Okay, so you probably recall within the last at least 2 years where some carriers have asked to be exempted from the commission's placarding requirements. So here's what staff created. Love to hear everyone's feedback. Exceptions. The commission may consider requests for exemptions from compliance with this section if the monthly average compensation exceeds $300 per trip for the prior calendar year. I don't know why that comma is there. Let me read it again. I want to say and. What if we say the commission may consider requests for exemptions for compliance if the monthly average compensation exceeds $300 per trip for the prior calendar year and is prearranged? I think maybe and. So what do y'all think? We're just trying to come up with some standards so it doesn't look like the commission is, okay, I like the color of your car, I like the make color of your car, so then you get an exemption from placarding.
Right. I think when
So
we were.
what would,
Go ahead, Charlie.
I was just asking, what would a scenario be where this?
Where an exemption would be allowed, Charlie?
Yeah.
What are they seeking it for? What kinds of?
Oh, sometimes I think it's been for a limousine, like if they are carrying someone who might be a public figure. So that due to the rate or the price for that particular ride, it might not look appropriate for the cost of that ride for your car to be for everyone to know that you're riding in a limousine.
So somebody would like to go incognito.
I see.
Yes.
So to use Tom Wolfe's phrase, the actual limousine liberals would be carried that way.
So $300, it would be the average trip would be $300.
Yes.
Jack, what's the going rate for a limousine ride? I would know.
Oh gosh, Charlie, so many that I've taken. Let me see. I went to Pelion in one, and I don't know. That strikes me. This is not within my bailiwick, but I do. I mean, and I'm sure the ORS has looked at it. I mean, $300 per trip. It does strike me as. I mean, I don't know where that. Yeah.
How can we do the $300?
Average.
Not doing rates.
No, well, we're not, but we're just trying to figure out what's the bar for you not to have a marked vehicle? What's the threshold that you have to meet?
But how would we know? How would they prove? How would the $300 be proven? We couldn't do it.
No, we wouldn't. They would have to provide their justification in their request for an exemption from this regulation.
We'll put it this way, to the ORS, is that helpful to the ORS to have that
Yes.
number in there? For some
I mean,
criteria?
I'll say this: when we reviewed it yesterday, we didn't take issue with what the commission did here.
Okay.
Okay.
Is there an alternative to a placard that would work for ORS? Like one of those things that you scan your phone on or something?
Oh. That's a good
That
question,
wouldn't be
Charlie.
quite so garish.
Did you hear what he said? Like,
I did not.
some neighborhoods have those bars. Like you don't have to put a sticker on your car, so the security knows they can scan your bar on your car, right, as to signify that you belong in the neighborhood or you're a resident of the neighborhood. And so, Charlie, you were asking about something like that, right?
I was just saying, it seems like this is all a cosmetic issue. Is there an alternative to a placard that would work for ORS enforcement?
Yeah, but you did mention something like the code.
Yeah,
QR.
like a
Scan
code
a QR code.
I mean, maybe what we
keyword.
can do is we can go back and evaluate this internally and then propose something and have have people provide comment on
Okay.
it.
I think
I
what
can
he's
even
saying
I
is,
can circulate it
Despite-
to Jack and Charlie prior to
Okay.
filing
You
it.
don't have to include us in it. I
No.
don't think so. I mean, my limousine use is not going to be affected one way or the other. So
okay. All right, 154, same markings as we mentioned before. The
And
PC.
Jocelyn,
yes.
sorry, we had an edit here, and I think ORS's intent is to move away from issuing permits and decals.
Oh, okay.
But in the event that we did, we wanted some fail-safe language. So what I would recommend is after where it says all motor vehicles, including substitute or emergency vehicles, and then there's obviously the strike-through operating under a certificate of public convenience and necessity shall have maintained.
Are we in 153? Nicole?
154. I'm sorry.
Okay. Thank you.
You're welcome. So all motor vehicles, including substitute or emergency vehicles operated under a certificate and strike through of public convenience and necessity, shall have maintained in such vehicles a permit, and insert a comma and insert the word if issued by ORS.
Okay.
And passenger vehicles shall have displayed on the front windshield of the power unit of such vehicles the license decal. Again, insert a comma, strike as, insert if issued by ORS upon proper registration of the vehicle.
Thank you. Great. Thank you. Thank you, Nicole. All right. So 155, transfer of a certificate without commission approval, just struck PCNN, FWA. I'm now on page 36. Section 158, same thing, strike PCNN, FWA, page 37. This is, I think, a recommendation. Or did you make this recommendation regarding bills of lading that they can either be in paper or electronic format?
I'm not sure about the paper or electronic format, but certainly the signature of the consignor or the shipper.
Okay.
That was ours.
I like it.
Okay.
And just as a side note, can we put a place marker on bill of lading? That bill of lading form is absurd. I mean, not the front of it, but the back of it is ridiculous. And what I'm seeing from this reg is that all that stuff on the back is probably not required. Or is it? But whether it's required or not, and it's not a subject for today, but the language on the bill of lading reads like something out of the 18th century. And I don't think anybody can understand it.
I'll go you one further, Charlie. I'm not so sure how it officially is the bill of lading.
Just because somebody photocopied it and put it on our website.
And I looked at this to see when and if it had become sort of blessed, and I'm not sure it has been. But we can talk about this another time for sure, because it's a different. Yeah.
Yeah, we don't have time today.
Yeah. One point, Jocelyn, on 103, 157,
Okay.
and again, I don't want to delve into this too, but it says duplication of authority.
Yes.
How can authority be duplicated now? I don't even know what it is. I mean, but I mean, maybe it can for passengers or something like that. I mean, how could you, if you've gotten a certificate from this commission that you're fit, willing, and able, how do you?
Okay, this is gonna sound crazy, but unless you own two businesses, is that a violation?
Some people do own two businesses.
Some people too own, okay, so that's not applicable.
I agree, Jack.
Just something to think about. It may have been something back when certificates were leased.
It seems to me that goes back to territory.
Mm-hmm.
Nicole, do you have any thoughts on the duplication of authority?
This is not one that we evaluated
Okay.
internally, so I mean, I'd have to take it back.
Thank you. Mr. Haruka. Okay, good. I want to sure he's okay. Thank you, thank you, Melissa. Okay, moving on. I think we were on 162. Everybody sees the change there. Don't think you have a problem with that. 164. Now we're into the insurance part, and we're just gonna have to get. As you can see on DMS, the Department of Insurance did file its recommendations, and we need to review those to see what we can recommend to you all regarding new limits.
I'm sorry to interrupt.
Yeah.
Just while we're still on this topic of some of these, 103, 164, suspension of operations.
Okay.
Um,
Okay.
there may still be some good reason that somebody stops operating, but there's language in this, specifically the second part of it, that talks about in excess of 12 months, that kind of ties back to that continuous operation that, you know, that you show for a transfer, or having to show that your certificate's not stale.
Right.
I'm not so sure that language continues to be, you know, to be relevant if you're talking about fit, willing, and able. But maybe it is. Again, I'm not so
You know
sure.
about those requirements, don't you, Jack?
What's that?
You know about those requirements, don't you, Jack? Continuous service.
I am not on the stand, and I will take the Fifth Amendment of no. But that is, I do know about that, and so it's not clear what the purpose of that would be necessarily in the ongoing environment.
Thank you. Okay. So the insurance limits.
Jocelyn, just
Okay.
a point of clarification on the schedule of minimum limits, and maybe this is just my copy, so if it is, I apologize. I could not tell what was different between what was proposed and what is current in the regulations.
Oh, we didn't change anything yet. Remember we did have an extra workshop too, I think, with Department of Insurance.
Okay.
And then they provided research, which is now on DMS. We just have not been able to, not at this point, provide recommendations for increasing or decreasing any of the limits, Nicole. We'll share those when we do.
Okay, so this is really just a placeholder to let us know
Yes,
that
ma'am.
that there would be some sort of change in pending.
That's why I left the yellow highlight.
Okay.
because
Thank you.
We know we need to come back to that.
Okay.
Yes, ma'am.
Thank you.
Yes, I see what you mean. And Nicole's referring to 103, 172. You're correct. The changes, there are no changes right now. Page 39, page 40. And I think all of the insurance, everyone. Okay, valuation. Hey, y'all, what is this? Oh, we haven't gotten to that yet. Nicole and Thomas, I think this is a recommendation from Office of Regulatory Staff for valuation. Great. So that's from the Office of Regulatory Staff's recommendations. Moving on to page 42.
Who is the STB?
State Surface Transportation Board. It's a federal agency.
So is that the?
Do they have interstate rules?
I'm sorry, you said, do they have interstate?
Oh, okay, interstate rules.
Yeah. Now, what number are you on, Charlie? What reg number?
I'm on page 41.
Okay.
Paragraph 2.
173.2.
Yeah, that's.
Recommendation.
Mhm.
So is that the origin of the 60 cents per pound?
I think, yeah, Thomas says yes. We talked about this too with
Okay.
Department of Insurance during the insurance forum,
Okay.
everybody.
Okay.
And surface transportation, they are mentioned in our definitions too. I had to refer to them too.
Oh.
They're mentioned in our definitions. But they regulate carriers. You have a certain size. I don't remember the size, but it sounds like 26,000. Okay.
Yeah.
My memory's not failing me. That's good. Okay. All right. So proof of insurance, and this is on the bottom of page 42.
Mm-hmm.
Copies of insurance, self-insurance, notices of cancellation must be provided to ORS, and then ORS does not need the copies, 3 copies. The original will be original copies, original forms will be provided to the commission. $190, ma'am. Oh,
We're not-
Miss, yes, ma'am. Yes, ma'am. Go ahead, Charlie.
178, the original forms of it. So the commission would start receiving Class E forms?
Proof of insurance.
I think, wouldn't those go to the
Well, they do go
ORS?
to ORS. Let me see where that came from. Hold on a second. 178.
So that should be ORS.
They should be ORS.
Okay, good catch.
I'm not sure why that second sentence
So
is neat.
yeah, I'm not sure. We'll strike the second sentence. So we'll just read. It will read like it reads now in the regulation.
Without in triplicate.
Certificates, yeah, certificates of insurance.
And Jocelyn, I'm sorry, in triplicate would also be struck.
Yes, I'm trying to figure out where the language came from. I don't know where it came from. What were you about to say, Janice?
I mean, surety bonds, we get copies of them, but they're talking about, boat areas here.
No, because when we receive them now, we forward them to y'all. I'm not sure where this extra came from. I don't think, Janice, we don't keep copies now, do we? Janice, we don't even keep copies. We just put them in the mail when we receive them. So I don't know where that came from. We're striking that. Oh, everybody, Miss Wheat needs a break.
Okay.
Okay.
Miss Wheat, what time? It's up to you. So, everyone, can we return 10 till 12, please?
Yep.
Thank you.
Yes, ma'am.
Okay, good afternoon, everyone. Again, we're going to resume. Nicole and Thomas, I'm trying to figure out. I'm still stuck on 178. And I was just looking at the commission order, trying to figure out why was that in there about us getting the original form. I can't figure it out because even the orders, most recent orders after the new Senate Bill 1045 was signed. I'm reviewing an order regarding insurance requirements for a taxi company online. So I don't know. I don't know where that came from. I noticed, do you all receive surety bonds? Do you still to comply? Okay.
Sorry. The regulations allow for it, but we don't,
Okay.
we don't have it. So
Well, I don't know. I don't know. I was trying to think of maybe someone on staff had a thought, but I can't think of what it was. So we're gonna, of course, remove that.
yeah, we're fine with the strike through the second sentence.
Okay. All right. So now we're on to page 43. Hope everybody's back. Mr. Tarani, are you back? Okay, great. Okay. So now 190. Remember, everyone, other than the PCNN language, which is struck, we talked about some other issues last year, including quotes, binding estimates. Remember that, Charlie?
Yeah, I don't think we needed it.
Yeah, okay. I removed that from, I think we originally had it in here. Maybe it wasn't here. It might be another section, but anyway, that if you'll notice that language is no longer in the proposed regulations. Now, we made a note here to refer to 173, which I think includes ORS's language about the valuation.
Yes, and
Okay.
Jocelyn, to that point, if we have the parenthetical referring to 173, I think what we talked about internally was striking, what would this be? 190 2C2 Romanet 1 and 2. So striking the basic amount insurance for excess.
Oh, number 3, right here. Nicole.
Under number 2,
under number
the 2 Romanets, the basic amount and insurance for excess, and then also striking number 3.
Okay, let me make sure I'm following you. Number 2, which is here.
Right, so 190. 2. C.
Oh, C.
2.
Okay.
And then striking basic amount
And insurance. Okay.
and insurance for excess, and then striking number 3 as well. And then you would just have the ministerial changes of changing 4, 5, 6, and 7 to 3, 4, 5, and 6 respectively.
You know,
Yes, Charlie.
I'm just looking at this. So all tariffs will include these charges. Bulky article, elevator, excessive distance. I'd never really thought about this, but I guess if you don't charge for bulky articles, then you would just say, you would include it, but you'd say no extra charge.
Yes. If
Okay.
yeah, do you think we need to change the language in parentheses in number 2, if appropriate for the particular move?
Well, no, because not all moves are going to have a bulky article or a cano or
Okay.
whatever. No, I guess it's fine. It's
Okay.
just kinda...
Cody, remember you and I were talking about something Charlie asked about, some services he thought he'd seen in a tariff. Did you find some? Remember the workshop, he and Mr. Popowski?
I think his concern is around movers who charge based on weight.
Oh yeah, Charlie. Remember when you were asking about movers who charge based on weight? Remember we
Yes.
talked? Okay, and so Cody's, as you know, has been reviewing the tariffs, and publishing the rates. And so we had a conversation. Did you find anything like what Charlie was talking about?
There's definitely some. I think we tried to kind of incorporate.
Okay. Give him, please. Oh, can you turn it on, Charlie? Cody, so everybody can hear you, please.
Yeah, sorry. I think we definitely saw some that were weight based, and we tried to incorporate that
Okay.
into the spreadsheet best we could.
Okay.
But it's in there that these are weight based.
You found some. So he did find some, Charlie. He was looking forward to, especially the issue
Yeah.
that you asked about.
I've had a couple of clients.
Okay, good. Thanks, Cody. Okay, Nicole, so I have your on page 44.
It's a governing publication.
Okay, now we're back on number 2, Charlie.
I'm
192.
sorry. I don't mean to cause trouble.
No, you're fine.
We're on 2C.
2C.
What is a governing publication?
Well, let me think about this. This is rules and regulations. Well, only thing that comes to mind for me, Charlie, is if there's something, a document that the carrier has printed that will govern
Just
or
put governing publications, if any.
Yeah, sure.
As it
We can do
stands,
that.
it's mandatory.
so what will become number 4, which is now number 5, governing publications will add if any.
Yeah.
Okay.
Okay.
Because sometimes I guess a carrier could have, pamphlets.
Yeah, there may be some point of reference or something.
Yeah, like pamphlets.
Yeah.
Yeah. Okay. Storage and transit bill of lading. You see anything else, Nicole or Jack, that you want? Okay. All right, we're going to move on then. 191. Does anyone oppose striking 191? Okay.
No objection.
All right. 192 on beginning on the bottom of page 44.
Jocelyn,
Yes, ma'am.
should 192 be struck given that
Oh.
Yes.
rates are no longer being regulated and 194 has been struck?
Mm-hmm.
We'd recommend striking that.
Okay, thank you.
And just, I amended 191 to delete paragraphs 1 and 2, and then just to have the remaining paragraphs say carriers need only file maximum rates with the commission and provide a copy to ORS or something like that.
Okay, now, so Charlie, so you're back on 190,
I'm
190.
back on 191, causing a little trouble. But
You're not causing trouble. So if
you
you go
don't-
back to
You
190.
don't have anything, if you
No.
strike all of 191, you've got nothing to provide for what you do with a tariff in your reg. So what I would suggest is you delete paragraph 1, delete paragraph 2, and keep paragraph 3, but delete of hazardous waste for disposal and holders of Class C certificate, and so that it reads carriers need only file maximum rates with the commission and provide a copy to ORS. I mean, isn't that the process pretty much now?
Well, I think I started commission to establish rates. So that's the heading of 191, which is really not true anymore.
No, it's not. I mean,
And I guess the question is that sort of subsumed under that now everybody, because I guess it used to be that hazardous waste and Class C or is that language already applicable elsewhere?
well, Jack, all I'm saying is reword it to say carriers need only file maximum rates with the commission and provide a copy to ORS.
Yeah.
Because otherwise you've got nothing in the reg that talks about filing your tariff.
Then that answered my question. Yeah, for sure.
Well, Charlie, why can't I include that under 190 as a number 3 and still
could.
strike 191 in its entirety?
That would be fine.
Yeah.
Okay.
Jocelyn, I'm sorry. Can you state your intent one
I
more
sure
time?
will. Yes, ma'am. So Charlie's sentence Charlie's suggestion for the sentence that reads, carriers need only provide maximum rates to the commission and provide a copy to the ORS, Office of Regulatory Staff. We would take that sentence and make it number 3 under 103-190. So we already have a number 1 that begins with no motor freight under 190. Number 2 starts with all tariffs. And then number 3 would read carriers need only. Does that make sense?
Yes. Yes, it does. Thank you.
Back to 190, number 1, is the commission still approving rates, fares, charges, classifications, and rules for services?
That's a good question.
All right, so number 1. No, they're not.
No.
Okay, let's take that.
So we need to say unless for service to be performed have been filed with the commission.
Yeah, and then
That's
tariffs
correct.
must be filed before commencement of operations in the heading
the
on
heading.
190.
In paragraph 1, you would delete shall have been approved.
Yes, shall have been filed, Charlie.
Filed, yeah.
Yeah,
Would be shall have filed
Yeah.
with the commission. Oh, this is tricky.
Okay. So we have the changes for 190. Then
Delete 191.
yes, we're deleting 191, deleting 192, deleting 193,
Yep,
194.
Yep.
And then under 195, we're now on page 45. Everyone, we're at the bottom of page 45. 103, 195, we just struck of PCNN and FWA. 196. Charlie, Nicole, Jack, do you all have an issue with 196 that they maintain copies of their tariffs?
nope.
No,
No.
and it should say for inspect, make available, shall maintain at each of its principal places of business in the state under glass. No, I think that's fine.
Yeah,
I was about to take notes. Okay. 197.
I think it goes.
Yeah, I think it goes to, well,
I mean, I don't know what an undue preference is, and that's always been what, somebody said is, I mean, you've got 197 and 198, which is variations, and the implication's always been that you're establishing an undue preference if you vary your charges.
Yes.
I mean, so it seems to me 197 goes because how do you establish an undue or unreasonable preference or advantage
I
to
agree.
any particular person, port, gateway, locality, or description? I mean, the last time this came up, a commissioner questioned, or the commission questioned whether you could charge a different rate in Charleston and Columbia. I think under the statute,
You can.
clearly can.
Yeah.
Yeah, and then take it even a step further, you're absolutely right, but without actual rate regulation of any types, then you're not even in a position to do that analysis of whether somebody is similarly situated or not. And I agree.
All right. 197. Strike 197. 198 has already been stricken.
Right.
Okay.
199 should go.
Okay, allowances. Charlie, what about this moves may be performed? Well, I guess it doesn't matter because you can do what you want.
Yeah.
Okay. Yep. Got it.
Freedom can be overwhelming.
Got it. Okay. 199.5 adjustment of bills. And I know we need to clarify, we're going to have to talk internally. If you recall last week's workshop about the legal rate of interest statute, the specific section. But we know we have to add that. Okay. number 3, and then page 47, 103.210, PCNN.
Wait.
Oh.
195, 199.5. That
Sure.
first paragraph needs
Okay.
massaging.
All right.
Because, see, this basically says if you vary from your filed tariff, that's the basis for overcharging or undercharging.
Mm-hmm.
So that's no longer the case. I mean, this probably just needs a rewrite. It needs to be if you vary from
Your
the
quote.
from the quote. And I don't know how you're going to undercharge somebody. We need to get rid of that. And I think, honestly, Jocelyn, I hate to heap more work on you, but you might need a quote regulation.
Like the binding estimate or quote? Is that what you're talking about?
I don't know if it's binding. I don't know what it is, but you may need something that says if you're going to charge rates other than those in the maximum tariff, you must inform the customer in writing or something to that, which you're kind of doing on the bill of lading, but there needs to, and it could be on the bill of lading, but I guess the point is, if Acme Moving charges me, quotes me a move and says, we're going to do it either for a fixed price of $1,000 or they charge me an hourly rate, and then I get my bill at the end of the move and it's different from what they quoted me and I want to complain about it, I think I've still got that right. But when I complain about it, ORS and the commission eventually are going to say, well, okay, Charlie, show me where it says you are going to be charged what you say you were going to be charged.
Mm-hmm.
And I need to have a piece of paper to wave around and say, this is what he quoted me. And I don't know if I have that under the current framework, and maybe Thomas can help us with this. Would the bill of lading be adequate for that, or do we need something else?
Charlie, I don't know if you could hear Thomas, but he said it basically
I
comes down. It basically comes down to whether you want to start regulating quotes or not.
Well, Nicole and Thomas, let me ask you something. What if someone has a complaint? Like if they've been provided a quote, wouldn't they complain to you all first? That what was quoted to me and then what I was invoiced are two different things?
Would, with that in mind, would the reg presumably say something like, rather than adjustment of bills, because again, it's problematic to put a standard or a benchmark in there other than the schedule, because the schedule was the thing, because that was the rate that you couldn't deviate from.
Right.
Now that's a moving target. Might the reg say something of a customer may complain? It would be to the ORS or to the commission, depending. I don't know whether you get into the informal, formal. Based on the proposition that the household goods motor carrier has charged more than agreed to by the parties. I mean, I don't know whether that's.
Well, and I'm fine. That's where I'm going, Jack.
Yeah.
I'd like them to be able to do that, but I also don't want it to become a he said, she said.
Right.
Thing.
Yeah. And would you be establishing that, that there's a process that, like you said, if you're using something other than what is in your published schedules, how do you memorialize that such that it becomes the benchmark? Is it quote? Is it bill of lading? Is it written?
In practice, most movers are going to do that. They're
Yeah.
going to give an estimate, and they're going to say, we'll do it for X number of hours and whatever. They'll itemize it in practice. But, I mean, it's one thing to say, I'll give you a binding estimate, and I think that's very easy. I told you I'd do it for $1,000, it's gonna be $1,000. But it's another thing to say, yeah, my tariff says $150 an hour for a truck and 2 movers, but since we're slow right now, I'll do it for 130. And somewhere that needs to be written down.
Mm.
And in practice, most movers are going to do that, but it's the ones that don't where that's going to be. You're going to get somebody walking in saying, he said he'd do it for 130. And he's going to say, no, I didn't. And you're going to have paperwork that doesn't shed any light on it. So I don't know where that is. I don't know. I don't want to prescribe a form, but I do want to say something to the effect is that if you vary from your maximum tariff, you need to state how you're doing that in writing and provide that to the customer, the shipper, before the move.
So if they charge anything less than the maximum rate that's on file, that's on the website, then a written quote
Yeah,
must be.
you don't have to give them a whole new tariff.
Right.
If it's going to be, it'll be my tariff, but we'll charge you 110 an hour or something. It'd be enough for me if they just struck through it or something. I don't know. If they gave them a sheet of paper, said $100 an hour, but they need something that establishes what they're charging for the move.
And with that in mind, and it's not helpful for purposes of today, but I'm gonna ask several clients about that operate in maximum rate environments in other jurisdictions already, how they manage that, how you memorialize it when you don't have the official document or official rate.
Okay.
Jack, I think North Carolina does it similar to the interstate system, in which you're allowed to give a binding estimate or a non-binding estimate.
Yeah.
And then they have forms for it. And their regs may or may not be the same, but
Right.
this statute is a little different from
Right.
some of the maximum rate jurisdictions.
Yeah.
But North Carolina, you can do it 2 ways, binding, just like in the interstate.
Okay.
I don't know that we want to make it that complicated.
No, but I was hoping that maybe there was something
They may, yeah.
that is simpler, but I will take a look at that and report back.
Okay. Now Nicole was going to add something, I think.
Oh, yeah.
Oh, I think what I was just going to say is it's clear that this section is probably going to be reworked. And I think, given that we have a very specific statutory mandate, I don't want to commit us to one idea over another today. So I think if, Jocelyn, if you were to propose additional language, we would obviously review it and provide our input at that time.
We'll do that, and we'll focus on the when written quotes are required.
Okay.
Documentation of quotes.
Yeah, we'll be happy to take a look at it.
Great. Thank you all
It
for
could be
bringing.
as simple as the basis for the charges shall be provided to the shipper in writing before the move.
Yeah.
I would use that as a starting point without making it too complicated.
Thank you. Okay, so
That's it.
199.5 will be reworked, and then let's see, is there anything else? PCNN on page 48, 49, copies of the lease agreement. Nicole, are y'all okay with that one? That's section 220. Did you have any?
No comment.
No comments there?
Nope.
Okay. 221. Nothing. We're on page 50. No changes. And 51. Oh, and I'm quite sure, or is that your recommendation for the manifest?
Yes.
Okay. For taxis, 231 for annual reports, we struck PCNN and FWA also.
I'm sorry.
No.
I'm sorry.
Which number?
This is on 231, the annual reports. We're actually
Great.
going to recommend striking the annual report.
Okay.
Um,
Because they don't all file, do they?
and apart from that, if the commission isn't going to have the authority to regulate rates, and I also think that there may have been the reporting requirement for passenger carriers a few years ago that was eliminated for similar reasons because economic regulations wasn't taking place anymore.
Right.
And I know from ORS's perspective, Regulation 230 requires that the carriers maintain their books and records. And
Right.
so if we were to conduct an audit, they would already have the responsibility to retain those.
Okay.
And so we would be able to conduct them without the need for them filing an annual report.
Yeah, and then for the assessment for the Class E, you could just review their accounting records.
Correct.
You don't need, okay, all right. So do you want to, let me write that down and I think we can, because it's really for, hey, Cody, do y'all use the annual reports for anything? I don't think you do. Other thing, I mean, they've used for the assessment and then you all, Nicole, you file a rule to show cause if they don't file the annual report with us.
Mhm.
So I don't know that we,
I think we just save it and look at it. There's not like any tracking or
yeah.
keeping up with it.
Okay, so, all right. Thank you for bringing that up. Moving on, 231, strike that. 232, we just deleted PCNN and FWA, page 52, 103.233. Same language has been struck. Also in 240, page 53, there's nothing. So give us an opportunity, everybody, to incorporate and recommend language. I enjoyed talking to all of you today. And then, Charlie, if there was some follow-up just on your end that you were doing, I know, Jack, you said you were going to talk to your clients about how they document quotes. So when we come back, hopefully you all will come back for the, our next version. And we'll have the insurance recommendations based on Department of Insurance research they gave us, okay?
I'm gonna run all this by Dalton just to make sure.
And Mitch, and Bowen, and Bob Bachman.
Are you going to report it at the next workshop? You have to do a presentation, slide deck and all.
Okay.
Okay.
Please, yeah.
Thank you all so much.
All right.
Have a good afternoon.
Thank you.
Okay.